Thank you very much, Mr. Chairman. In discussing the Juvenile Justice Bill, I've listened attentively to the Minister, but I think we need to ask ourselves a basic question. What does justice seek to serve? Does the state exercise its punitive powers in order to be vengeful, to extract an eye for an eye, to punish in a manner that can only be described as primitive? Or do we hope to use the justice mechanism as a corrective to wean people from error and to rehabilitate the young? This question is all the more necessary in the case of children who commit crimes, because they're not often sufficiently mentally or emotionally developed to understand the gravity of their wrongdoing. Are we as a society now starting to take revenge on children? I understand where this is coming from, Mr. Chairman. We were all horrified by the terrible attack on Nirbhaya in 2012. It shocked the national conscience. I myself met the parents of Nirbhaya not once but twice, so I have great sympathy for their plight. But to actually take that case and to say that, oh, because according to the media, some of these heinous acts were committed by a juvenile, that he will get away with minimum punishment and therefore the system should be changed, this is terrible. A lot of people are saying things like, if he's old enough to rape, he's old enough to hang. I can understand their anger, their emotional, but, Mr. Chairman, the problem with such an approach is twofold. First of all, it treats children as adults, which is simply wrong, morally, legally, constitutionally, ethically and emotionally, as I shall explain. During the immediate aftermath of the Nirbhaya tragedy, the UPA government undertook extensive consultations, several months, which confirmed that the arguments for doing this were based on fear, moral outrage, misinformation and ignorance. This is why we did not succumb despite popular demands for a change. And in any case, Mr. Chairman, entire laws which apply to cases of all juveniles across the board cannot and should not be determined on the basis of one bad example, no matter how horrifying or horrible it might be. Laws are considered and studied instruments of justice. They cannot be based on one instance alone. It is a duty of the government of the day to ask itself whether good law and good justice can ever be born out of an impulsive reaction to an emotional situation or a headline. The Juvenile Justice Bill, despite a few positive provisions regarding adoption and so on, has put forward this House a most regressive proposal. It is actually the very fact that we are sitting in this House discussing the possibility of convicting children as adult criminals is really primitive. It has pushed us back to the darkness of the 19th century. Today is a black day for this Parliament in terms of modern jurisprudence. I must sadly accuse the government of having chosen political expediency over justice. As the Minister has explained, they'll create a selective system whereby the Juvenile Justice Board will have the discretionary power to transfer a child in the age group of 16 to 18, accused of certain crimes that she has mentioned, to an adult criminal justice system for trial and conviction. As the Justice Verma Committee observed in 2013, and I quote, "We cannot hold the child responsible for a crime before first providing him the most basic rights given to him by the Constitution." What are these rights? The provision under Clause 16 and Clause 19(3) of the Juvenile Justice Bill is not only in contravention of the most important fundamental rights guaranteed by a Constitution, but is in conflict with its own objects and principles, Mr. Chairman, here in this document, the bill before us. The fact is, as she points out, on the one hand, it replaces the word juvenile with child in conflict with the law, which is supposedly more humane. But this very child in conflict with the law is meant to be tried for adult offences, an inhumane idea conceived by this government. And even here there is a flaw. The terms child alleged to be in conflict with the law and child found to be in conflict with the law are not defined clearly and are used interchangeably in this bill, even though there is an obvious difference between alleged to be and found to be. This is just one more confirmation that it's a bad law, badly written and badly thought through. Now, they claim in their statement of objects and reasons that they're going to be actually catering to the needs of the child in conflict through proper care, protection, etc. It's a child-friendly approach, the Minister says today. But the child-friendly approach suddenly disappears when you're between 16 and 18. International examples, I can give you many, Mr. Chairman, but I don't want to use up your time, show that transferring children to the adult system has failed to prevent repeat offences, failed to reduce the juvenile crime rate, failed to promote public safety. In fact, this bill will actually increase the risk to public safety, Mr. Chairman, because convicting a child in an adult criminal trial will deny the child the fulfillment of his basic rights, will prevent his physical, emotional and intellectual development, and will eventually, we will be churning out more hardened criminals than reformed adults. There is a US study that has established that 80% of the juveniles released from adult prisons go on to commit more serious offences. So what this government is proposing, treating a child this way, jailing children for life, is neither in the best interest of the child nor in that of our society as a whole. And the government has failed to say, the minister says that crime figures have gone up. This is simply not correct. They have not studied the figures accurately, because this very minister 14 years ago introduced the more progressive law that we have, that we are now replacing. She had then defended in 2000, I've looked at her debate, she had defended this as a child-friendly approach at that time, saying it was needed to replace the pre-2000 provisions. And she had said that her Act of 2000 would establish a reform protection system for all children. I'm so disappointed that today the same minister 15 years later has introduced a bill to change her own progressive legislation and replace a reform protection system with a harmful punitive system. Let's look at our facts, Mr. Chairman. There are 472 million children in our country. Do you know only 1.2% of all of them have committed crimes? Now, I'm talking 2012 and 13 figures. The number of children who committed serious and heinous crimes was even more minuscule. In 2013, of all the children arrested for crimes under the Indian Penal Code, 2.17% were accused of murder, 3.5% of rape. Now, this is 2% of 1%. You see what I'm talking about? We're talking about a handful of cases in this country, according to our national crime statistics. How can we pass a law that will jeopardize the other 99.98% children in this country because we are overreacting, or this government wishes to overreact to these handful of cases? And by the way, these figures are only FIRs registered. I don't have figures for who was actually found guilty. Many of these children may not even have been guilty. Now, what this government should be doing is properly implementing the existing provisions for rehabilitating children in conflict with the law. Instead, it's shrugging off its responsibility by holding the children responsible for the failures of the juvenile rehabilitative system. The government should fix the juvenile justice system, not bypass it and victimize our children. Furthermore, Mr. Chairman, please let us understand one thing. This law will predominantly affect the country's poor and marginalized sections of our society, OBCs, SCs, STs, minorities. Take my word for it, a majority of children in conflict for the law come from illiterate families, poor homes, or even homeless. I have statistics. 77.5% of the arrested children in 2013 came from families with a monthly household income of less than 4,200 rupees. That's how poor these children are. 87% had not received a higher secondary education. These are the ones you're trying to punish instead of trying to give them education, give them an opportunity to integrate into our society. Is this really a question of justice? Is this fairness, or is it political convenience for this government? The provision also lacks constitutional validity, selective and unequal treatment of children, violates the fundamental rights guaranteed under Article 14 and Article 15(3). Equal protection of the law, Article 14 is gone. Equality before the law, Article 14 gone. Article 15(3) allows the state to enact special provisions for protecting children because they are vulnerable. Now, what they've gone and done is, Clause 7 of the bill is also in contravention of Article 21 of the Constitution, which clearly states that a person should not be awarded a penalty greater than the one provided for in the law at the time of the commission of the offence. But if you commit an offence when you're 16 and they arrest you when you're 21, forget it. You will be tried as an adult under this law and convicted. The fact is, this violates the constitutional prohibition on procedural arbitrariness under Articles 14 and 21, as well as the test of fairness in Article 21, and the 1 month given to the Juvenile Justice Board for their preliminary inquiries is absurdly short and could lead to a presumption of guilt, a presumption of guilt, not of innocence, which itself violates the Constitution. Now, you look at the Statement of Objects and Reasons, Mr. Chairman, it says that one of the objectives is to bring the country's laws and the current juvenile system in conformity with the United Nations Convention on the Rights of the Child in 1989. In fact, the bill actually specifies this, but the bill actually is abandoning the convention by differentiating about children between 16 and 18 years. Article 3 of the convention declares that states party to the convention ought to give importance to the interests of the child over public safety even, contrary to what the minister and her bill prescribe. And what we're looking at, very honestly, is that the entire principle of the presumption of innocence has been thrown by the board, because this judicial, this juvenile justice board that is going to determine whether a child should be tried as an adult, they're not going to be capable of examining and establishing guilt. The Justice Verma Committee had said that such a change would, in fact, actually violate Indian guarantees to the international institutions. The bill also violates the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, 1985, the so-called Beijing Rules, which require a child or a young person accused of an offence to be treated differently from an adult. It also violates the United Nations Rules for the Protection of Juveniles Deprived of Their Liberty, 1990. I mean, the bill is an equal opportunity offender, Mr. Chairman. It violates every principle it can possibly violate. Condemnation by the UN Committee on the Rights of the Child will surely follow. And this government may not be embarrassed to shame us before the world, but there is no reason for us in this parliament to accept this retrograde step without a fight. Clause 22 of the bill, at least mercifully, thankfully, exempts the child from death penalty. But the truth is, Mr. Chairman, that all it does, nonetheless, is risk the child being detained for 20 years. And he will be a hardened criminal after 20 years, you can be sure of that. He will not reintegrate into society when he spent 20 years in jail. They could have easily just changed the 3-year rule to a 6 or even 7-year maximum instead of doing this to a child. What provisions has the government made to jail convicted children in separate facilities from hardened adult criminals? I see nothing in this bill. Are there opportunities available for their education change? I see nothing in this bill. The fact is, sir, even the standards available for determining the age of a child in our country are extremely minimal. What do we rely on most of the time? A matriculation certificate or a birth certificate from a school or a municipal corporation. But many government and municipal schools often record age based on the physical appearance of a child. And the children who would be immediately affected by this law, if we pass it today, were born at a time, that is 2001, when the level of birth registration in this country was 58%, Mr. Chairman. 58% of the children in this country were registered in 2001. So everyone is going to be, it's a question of guesswork as to how old they are. And in fact, the proof of age can have drastic repercussions. You may actually convict somebody saying he is 16 when he's actually 15 and somebody gave a bigger age to admit him into school. If you don't doubt me, ask General V.K. Singh, he'll explain to you how that works. Now, the fact is, there are no specific provisions or guidelines for a female juvenile in conflict, nothing for sex offenders. Do you realize this law can be so easily misused? If children, for example, teenagers are found engaging in consensual sex, the male can be charged with rape and sent to the adult prison now. This is absurd. An 18-year-old boy and a 16-year-old girl, a 17-year-old boy and a 16-year-old girl, this can now happen to that child. I just want to stress, Mr. Chairman, I realize my time is up, just 1 minute, 2 last points. One is that there is an old established principle of law, lex injusta non est lex. An unjust law is no law at all. I just want to stress that this is an extremely unjust law. The Supreme Court has on many occasions opined that persons under 18 years of age must be treated as juveniles, should be given separate treatment for offences committed. And the fact is that our justice should be about rehabilitation, not about retribution. The truth is, the need of the hour is not this bill. What is needed in our country is child protection, development under juvenile law, to be given sufficient attention and investment. This government is starving the juvenile justice system. They're not giving money. There's not enough juvenile justice boards. There are not enough child welfare committees. There's not enough institutional services such as shelter homes, special homes, observation homes. There is no effective monitoring and coordination mechanism. Can the minister truly argue that our country possesses adequate administrative and judicial provisions to operationalize this bill? Will the finance minister, I see the Minister of State is sitting there, will he give her the resources she needs for this, or will the finance ministry do to her ministry what they did on the Anganwadis, where they don't have enough money? Already this year, what has happened? 400 crores have just been given for the integrated child protection scheme, 11% less than the revised estimate for last year. Budgetary allocations for the development of children have faced drastic cuts. There's been a reduction of 55% in allocations to the states. So how are you going to strengthen the system and administer the provisions of this bill? If the government starves them financially, this bill will be a bigger disaster. I want to stress, Mr. Chairman, in conclusion, that children below the age of 18 must be saved from prison, must be protected from the regular criminal framework. We cannot sacrifice a child to appease popular political sentiment. All children in conflict with the law and those in need of care and protection should receive the necessary care, education, counselling, and the state should work to reintegrate them into society through rehabilitation and assistance, not to cast them aside by regressive measures of retribution. If we pass this bill, I say to our Treasury benches, posterity will judge us harshly, Mr. Chairman. The child is our future. We must protect the child, rescue the child, not destroy the child. Thank you, Mr. Chairman.